So my objective today is to give you about a 30-minute version of my magnum opus, which is 500 pages. It's a doorstop, and if you have trouble sleeping, I suggest you buy it, which is called Freedom's Anchor, an introduction to natural law jurisprudence in American constitutional history, in which we reviewed every U.S. Supreme Court opinion that expressly accepted or expressly rejected the concept of natural law or natural rights. Unfortunately, the conclusion after this four-year gargantuan study is a very sad one, because the Western jurisprudence has almost totally rejected the concept of natural law and natural rights in return for positivism. So I would begin teaching law students by asking them this question. The First Amendment, as we all know, and I'll use this as my paradigm for today, states in part, Congress shall make no law abridging the freedom of speech. So if the states ratified an amendment repealing the First Amendment, would we still have the freedom of speech? And everybody's hand goes up and said, well, no, we wouldn't if they ratified it. Okay, then you push them a little farther. Suppose the legislature repealed the laws criminalizing bank robbery or rape or murder. Would bank robbery or rape or murder still be wrong? And maybe just a few hands, they're not sure about the answer of that. And that's the way I begin introducing them to the concept that our rights do not come from the government. They come from our humanity. This is, of course, an extrapolation of Aquinas, since he never really spoke about rights, at least not rights as we understand them. So if you accept positivism and the First Amendment is repealed, then there is no freedom of speech, and the government is free to interfere with speech, even the speech that we engage in today, which is marvelous, instructive, at times combative, and always illuminating. We're in a place where the freedom of speech is recognized, but there are places on the planet where it is not. So this is the way of instructing the difference between rights coming from our humanity and rights coming from the government. Unfortunately, from the time of the adoption of the First Amendment, almost immediately the government began to degrade it. So we'll go back a few years to the Declaration of Independence, when Jefferson wrote that all men are created equal and endowed by their Creator with certain inalienable rights, and among these is life, liberty, and the pursuit of happiness. And the only moral government is one that is based on the consent of the governed, consistent with not anything the British Parliament wrote, but the laws of nature and nature's God. Now, he could have appealed to the British Parliament. Instead, he appealed to the Creator, the laws of nature, and of nature's God. It is very clear from whence he is deriving the argument that the American colonies have the natural right to secede from Great Britain. He would later argue that the colonies had the right to secede from the Union, and the counties had the right to secede from the colonies after they became states. When the Constitution was ratified by the 13 colonies, now 13 states, 5 of them said, we're going to leave unless you add a Bill of Rights. And James Madison, known as Little Jimmy, I'd like to stand next to him in heaven because I'd look like Shaquille O'Neal next to Little Jimmy Madison. But Little Jimmy Madison, whose job it is to write the Bill of Rights, crafts it recognizing natural rights. So again, the First Amendment doesn't say Congress shall grant the freedom of speech. It says Congress shall not infringe upon the freedom of speech. And Madison insisted that the word "the" precede freedom of speech in order to recognize the framers' recognition of its pre-existence of the government. It's a pre-political right. Well, if it's pre-political, where does it come from? It comes from our humanity. Then Madison has this great debate with Alexander Hamilton, who didn't even want a Bill of Rights. And that is, what do we do about rights that are too numerous to write down? So they wrote down, think as you wish, and say what you think, and publish what you say, and worship or not worship, and associate or not associate, protect yourself using the same means that the government uses, Greg, carry the same weapons that the government carries, thanks to Justice Scalia. It took them 200 years to agree on that. the right to be left alone, the quintessentially American right, the right to due process, notice, hearing, fairness, trial, right to appeal. All these rights are articulated in the Bill of Rights. And then Hamilton says, well, Jimmy, you write down 10 rights, I'll give you another 10. And Jimmy says, okay, you give me 10, I'll give you another 10. So they have to figure out a way to encompass the universe of human rights without enumerating them, because the document would be too weighty and it could never be complete. And that is Madison's genius and his pride and joy, which is not the First Amendment, but the Ninth. And the Ninth Amendment says the enumeration of rights in the foregoing, the first 8, shall not be used to disparage all the other rights retained by the people. That's the way Madison was able to incorporate into the Bill of Rights the concept of our rights coming from our humanity. So we have Jefferson appealing to God, laws of nature, and nature's God. We have little Jimmy writing the Bill of Rights using language unmistakably clear that rights pre-existed the government, and then we're off to the races. And the races begin in 1798 when the Congress and the country go through something that's inconceivable today, at least in America. Fear of the French. What were they worried about the French for? Well, the French had just cut the king's head off, and they were worried that something like that would happen in the United States. So they enacted the Alien and Sedition Acts, which basically said, you want to come to the U.S., come here, we'll give you 50 acres of land. You only have to wait 6 months, you can become a citizen, unless you're French. Then you have to wait 14 years. Oh, and by the way, whoever shall criticize the president or the government shall be guilty of a felony, punishable in a federal prison by up to 2 years. Well, now, wait a minute. How did the same generation, in some cases the same human beings that had just written, Congress shall make no law abridging the freedom of speech, enact a law that abridged the freedom of speech? St. Augustine would call it libido dominandi, the lust to dominate, even by the small government people, although these were mainly the Federalists who wanted a strong national government and didn't care about the states. There's a famous case involving Congressman Matthew Lyons, who mocked President Adams' waistline by calling him in public his rotundity. And for that, Congressman Lyons was prosecuted and convicted under the Alien Sedition Act and spent 2 years in a federal prison in western Massachusetts, and his 480-acre farm in Vermont was confiscated. When he got out, he did something which the Americans know this. If you're from Hudson County, New Jersey, Chicago, Bishop Barron, or New Orleans, you're familiar with this, or Boston. He ran for re-election from his jail cell, and he won. And when he got out of jail, he went to Washington to be sworn into the job he formerly had, and instead of his rotundity, he found the tall, thin, red-haired Thomas Jefferson, who proceeded to pardon him, which returned his 480-acre farm, couldn't return the 2 years of liberty that had been stolen from him, and the Alien and Sedition Acts had been repealed. That began a series of the recognition of natural law by the Supreme Court. I'm going to keep the Civil War, otherwise known as the war between the states, out of this because it's sui generis and it would divert us down some rabbit holes that we don't want to go to now. And the Congress, for the most part, respected, and the courts a lot respected the concept of natural law and natural rights. The greatest example of this is a case called Lochner versus New York. Now, this is 1904. Unfortunately, this is not only the great example, it's the last example. So the state of New York, under pressure from labor unions, enacts legislation that says bakers, no other job occupation, but bakers cannot work more than 40 hours a week, divided by certain days. You couldn't do it in 3 days, whatever. And Joe Lochner operated a bakery, and he didn't want the unions there, and he negotiated with his bakers, and they worked 60, 70, 80, 90 hours a week, and they slept on the second floor of the bakery, and they were happy, and Joe was happy until the state of New York indicted him, criminally prosecuted him for violating the law that says thou shalt not pay anybody and hire them to work for more than 40 hours in a week. He's convicted all the way up the New York state system, and then he appeals to the Supreme Court, Lochner versus New York, and the Supreme Court reverses the conviction on the basis of economic liberty, the freedom to trade the sweat of your brow to anyone who will pay for it, under such circumstances, in such a place, and in such a manner as you and the person with whom you're trading it agree. Now, for those of us who believe in small government and believe in maximum individual liberty and believe in natural law and believe in natural rights, this, unfortunately, because it's so long ago, it's 1905, is the height of the acceptance of natural rights and natural law in Supreme Court jurisprudence. We then get into the progressive era in American history, and then we get into World War II, where there's a series of decisions that profoundly and directly assault these natural rights, not the least of which is called Wickard against Filburn, where a farmer is growing wheat in his backyard, and his wife is grinding all the wheat into flour and baking goods in their home. Doesn't sell it, no commercial activity, but the courts found that it was regulated under the Interstate Commerce Clause because he used water to water the field that came from a river that originated in Indiana. And the river made its way into Ohio, and therefore there was an implication of interstate commerce. And this is positivism at its extreme. Well, no, I'll give you a few more extreme cases, but whatever. It allowed the federal government to regulate how much wheat Mrs. Filburn could harvest and grind into flour. None of it sold. The next monstrosity in World War II is called In Re Quirin. This is the Nazi saboteurs that were caught in Amagansett, New York, and Punta Vedra Beach, Florida. They actually took 2 submarines under the Atlantic Ocean. When they landed, they buried their Nazi uniforms in the sand, and they put civilian uniforms on. They all spoke perfect English. They were arrested, and they were about to be hanged when 2 of them said, well, wait a minute. I was born in Louisiana, and the other one goes, well, I was born in Chicago. You guys are Americans? Well, yeah, we were born in Louisiana and Chicago. We're Americans. What does the Supreme Court do? The Supreme Court allows FDR to hang the 6 without a trial who were Germans, but accords due process rights to the Americans, even though the amendment that protects due process, the Fifth Amendment, protects all persons, not just Americans. The Supreme Court made, at the height of wartime, that positivistic difference and recognized the natural rights only of the due process of the Americans and not the natural rights of the Germans. One of them died in jail. The other one survived the war and went back to living in the United States when the war was over. The third monstrosity during World War II, you all know this, is called Korematsu versus the United States. This is the Japanese exclusion laws in which the federal government constructed, this is their phrase, not mine, concentration camps in Utah and arrested 125,000 Japanese Americans, human beings born in the United States but of Japanese ancestry, and confined there. And Fred Korematsu refused to go. Well, Fred was arrested and prosecuted in federal court and was convicted by a jury trial, and the conviction was upheld by the Ninth Circuit, and that went to the Supreme Court. And a bitterly, bitterly divided Supreme Court upheld his conviction under some sort of a theory of military necessity. This is not, strictly speaking, positivism. It's almost the inverse of positivism because there's no clause for military necessity in any statute or in the Constitution. The court just made it up in order to justify the conviction of Fred Korematsu. If it had gone the other way, the feds would have had to release the 125 others that it already was incarcerating. World War II is over, and we have a very interesting phenomenon in Nuremberg, Germany, called the Nuremberg trials. Well, what were they, under what law were they tried? The State of Israel didn't exist. German law arguably permitted these German soldiers and torturers and concentration camp operators to do what they did. Whereupon, you can't believe this, the Russian prosecutor suggested, this is Stalin's good buddy, the Russian prosecutor, well, why don't we come up with some theory of natural human rights and try these ex-German generals and politicians for violating the natural human rights of the Jewish people whom they slaughtered and tormented. We know this from the notes of Bob Jackson. Bob Jackson was a former Attorney General of the United States on the U.S. Supreme Court, took a leave of absence from the Supreme Court in order to become the chief American prosecutor, and he wrote some notes which he would publish years later, accrediting the Soviet prosecutor with coming up with this idea. Clearly, a validation by an international community under stressful and striking circumstances, post-war Germany, Nazis who were still alive, senior Nazis, used to try them. Half of them were acquitted, half convicted, a few hanged, and a few served their terms in jail. We come back to the United States now and are confronted with a case that I think my colleague Elizabeth will discuss in a minute, called Griswold versus the United States. Excuse me, Griswold versus Connecticut. Griswold was an OBGYN physician who prescribed birth control to his female patients, even though the state of Connecticut had made it a crime to distribute any birth control devices. He's convicted in the Connecticut system, and the Supreme Court reverses. Now, the Supreme Court is not exactly clear as to why it reverses, and the decision is a little crazy by Justice Douglas. He's been mocked for the decision even generations after he died, because he came up with the idea of shadows and emanations. Somewhere in the shadows and emanations of the language of the Constitution is the right to be left alone. Justice Goldberg, Arthur Goldberg, who would eventually leave the court to become LBJ's ambassador to the UN. Inconceivable today that somebody would leave the Supreme Court to go to the UN, Jeff, but that was then. He writes a concurring opinion which says, you know, I think the right to be left alone is one of those rights that Madison didn't mention specifically in the Ninth Amendment. And why don't we call it by its name, privacy? The right to be let alone was articulated first by Justice Louis Brandeis in a case 40 years earlier involving wiretapping, in which it was a dissent. 40 years later, in 1963, it becomes the majority opinion, and it begins the recognition of the right to be let or the right to be left alone, either under the Ninth Amendment or under something that the court would eventually call, and this is its modern day secular term for natural rights. It's a term that a lot of us don't like, but it's a term the court uses, called substantive due process. So there are two due processes, even though there's only one in the Constitution. Secular due process was made up by the court. The one in the Constitution is the one in the Fifth Amendment. The government shall not take life, liberty, or property of any person, not just Americans, FDR, any person without due process, notice, hearing, fairness, trial, right to appeal. And the statute and the crime, of course, have to pre-exist whatever the person is accused of. The other one that the court sort of made up, and I don't know where they got this name from because it has nothing to do with process, they call substantive due process. It is their secular phrase instead of natural law. I once said to Justice Scalia, in one of my many wonderful conversations with him, one of the great joys of my life was being a very dear friend of his in the last 10 years of his life. And Nino, why don't you just call this what it is? call it natural rights.
Oh, it's too Catholic. Kennedy would never vote with it.
What do you mean Kennedy would never vote with it? He's your neighbor. He goes to Mass every day.
You know, he's a WASP. He's sort of pretending he's not Catholic. He'd never vote for it, and I'd never get 5 votes.
Well, write a dissent and call it natural rights.
Well, if I write the dissent, then I'm going to lose the ultimate outcome of the case.
So he went along with calling it substantive due process. What does it protect? Well, it protects those areas of human behavior immune from governmental reach. We would like to think they are natural rights. Think as you wish. Say what you think. Publish what you say. But the court has limited them, and again, Elizabeth will go into this in more detail. If I'm stealing any of your thunder, I expect you to interrupt me, Professor. We talked about this on the bus ride on the way home. We actually bonded. We found out we were both taught all this by the same wonderful human being, Professor Charlie Rice, who had a profound influence on both of us and was a champion of natural law. And it was on just Ronald Reagan's short list that included Justice Scalia, Rice, Scalia, and 3 others unknown to history. The idea that this area of human behavior that the government can't reach, which the courts will call substantive due process, is limited to intimate personal behavior. So your right to choose your mate, Loving versus Virginia, state of Virginia, as late as 1967, prohibited interracial marriage. And the Supreme Court said, no, you have a fundamental right to choose your mate. Transfer that to 2015 to Obergefell versus Hodges, sometimes called Obergefell versus Ohio. That's the right to choose your mate of the same gender, using the same logic as Loving v. Virginia, one producing a salutary effect, the other producing effect that I can't imagine Thomas Aquinas would have approved of, but nevertheless, under this same rubric of substantive due process, that area of human behavior not reachable by the government. We also have, in between Loving and Obergefell, a case called Lawrence versus Texas, which prohibits the states from prohibiting sexual relations amongst consenting adults irrespective of gender. The only prohibition is age and mental capacity to consent. So as the Congress, writes more and more laws, believing it can right any wrong and regulate any behavior and tax any event and intrude on any process, and as the Supreme Court follows its motto, which is not equal justice under natural law, but equal justice under law, which in America means positive law, the nihilism backed by force that the Congress and the presidents use, there's very little reference to American law. I've asked Scalia, did anybody ever argue in your years before the Supreme Court they had a natural right to do anything?
No, but if I mentioned that from the bench, Tony Kennedy would say, well, where'd you get that from? Your buddy Napolitano, nobody else talks that way.
I was once at a dinner party with him, and he said, let's propose a toast. I said, all right, you propose the toast. Who do you want to propose it to? He said, I want to propose it to Pius XII, but I don't remember how to say it in Italian. I said, Pio XII. So he stands up and he says, to the greatest pope ever to reign over me in my lifetime, Pio XII. And the crowd roars, but they didn't know what he was talking about. But that was Justice Scalia. Does Congress shall make no law really mean no law? Now, the court never, one exception, which I'll tell you about in a minute, publishes a transcript of its oral arguments in its written opinions, because the oral argument is not the law. What the justices say from the bench is not the law. What the lawyers say to the justices is not the law. What is the law is the written opinion afterwards. But in the famous Pentagon Papers case, where Daniel Ellsberg, an employee of the Defense Department, stole 7,000 pages of top secret documents revealing that LBJ and his generals were lying to the public during the Vietnam War, and he gave those documents to the New York Times and the Washington Post during the Nixon administration. And the Nixon administration got a federal judge that Nixon had appointed to enjoin the publication of the documents. The Supreme Court reached down to the trial court and took the case, didn't even wait for it to go to the appellate court, and heard oral argument. And during oral argument, Justice Douglas, the author of the Griswold opinion, says to the Solicitor General, the government's chief lawyer. Now, we only know this because they printed this colloquy in the middle of the opinion, something they have never done before or since. Mr. Solicitor General, does no law really mean no law? No answer. Mr. Solicitor General, does no law mean no law? He can't answer that because if he says yes, then his case against the New York Times and the Washington Post collapses. If he says no, then he has to explain what does it mean and what are the standards for what it means. So he puts in some gibberish. Douglas was so unimpressed with the gibberish, he insisted that that colloquy be printed in the opinion. The opinion, of course, is a 6-3 opinion that basically says that the publisher is immune from criminal and civil liability because Congress shall make no law really does mean that the press is the eyes and ears of the public, and the public has the right to know a matter material to the public interest, no matter how the public got it. Footnote to the story. Ellsberg is prosecuted for espionage, and he clearly committed espionage. He had a top secret security clearance. He took the documents. He not only stole them, he not only gave them away, he gave them to the press. He published them. In the middle of his trial, this wouldn't happen today. Today they would do this electronically. The FBI broke into his psychiatrist's office and stole the psychiatrist's notes of what Ellsberg said and revealed to the psychiatrist. When the trial judge found out about this, he threw the case out, and the feds were so embarrassed, they didn't appeal, and they didn't re-indict him. Today, of course, there wouldn't be any break-in. They would do what they do to all of us every day and are doing as we speak, digitally. So, all right, I'm sorry, it's been a round. I feel like I'm talking too fast, but again, I'm from New Jersey. I know this, and the sisters admonishing me. One more sentence, 2 more sentences. I've done my best to attempt to explain to you what took me 500 pages in the book to explain the degradation of natural rights and natural law down to positivism. Here's one editorial from me. If we abandon traditional natural law principles in favor of an exclusive sort of positivistic certainty, we will learn to our peril that those certainties are based on nothing certain, but just the whims of those in power. Thank you, my dear friends, for listening.